Hello students, today we are going to discuss local self-government and the mandates of 73rd and 74th Amendment Act. This article would enable the students to understand the importance of local self-government, the features of 73rd Amendment Act, the mandates of 74th Amendment Act, local governance in Jammu and Kashmir, and an analysis of Gram Panchayat Development Plan. To start with, the 73rd and 74th Constitutional Amendment Act in India was enacted in 1992 and 1993, respectively, aimed to decentralize power and promote local self-government. These amendments added provisions related to panchayats and municipalities to the Constitution of India, recognizing them as institutionalized bodies with constitutional status and power. The amendment aimed to empower the marginalized section of the society and provide them with direct say in decision-making. The 73rd and 74th Amendment Act have had a significant impact on decentralizing power in India by transferring power from the central and the state governments to the local level. This transfer of power has led to a more democratic form of governance as it allows local communities to have greater say in the decisions that affects their everyday life. The amendments have also led to a more participatory form of democracy, as local communities are now able to participate in decision-making processes and hold their elected representative responsible for their act. These acts provides a basic framework of decentralization of power and authority to the Panchayati Raj or municipal bodies at different levels. However, responsibility for giving it a practical shape rests with the states. The states are expected to act in accordance with the spirit of the acts for establishing a strong and viable system of local self-government across the country. The 73rd and 74th Amendment Act to the Constitution of India constitutes a new chapter in the process of democratic decentralization in the country. In terms of these amendments, the responsibility of taking decisions regarding activities at the grassroots level, which would affect people's life directly, would rest upon the elected members of the peoples themselves. By making regular elections to Panchayati Raj and municipal bodies mandatory, these institutions have given greater choices and due place in the democratic setup of the country. Local self-government is the third stratum of the government, the first two being the central and the state government. Presently, rural self-government, that is Panchayati Raj system, is working in accordance with the 73rd Constitutional Amendment Act, and urban self-government, that is the municipal bodies, is working in accordance with the 74th Constitutional Amendment Act. Following the enactment of the 73rd Constitutional Amendment Act of 1992, almost all states in India passed legislation in continuity with the provisions of the Amendment Act. There are some important states which have two-tier Panchayati Raj systems, one at the village level and the second at the district level. There are also other states where Panchayati Raj institutions is a three-tier system: Gram or Gaon Panchayat at the first level, Samiti, Mandal or Anchalik or Taluk or Block or Janpad or Union or Kshetra as the second level, and Zilla or District Panchayat at the third level. At the rural level, the Gaon Panchayat or Sabhas constitute the foundation of the Panchayati Raj system. Gaon Sabhas perform the functions and power entrusted to them by the state legislatures. The 73rd Amendment Act aims to provide three-tier system in the local self-government through elections held regularly every 5 years. The Act also provides reservation of seats for scheduled caste and scheduled tribes, also women. Moreover, the Act provides for a State Finance Commission to make recommendations regarding financial powers of the panchayats and to constitute district planning committees to prepare draft development plan for the districts. Provisions has also been made to constitute a state election commission in every state to supervise, direct, and control regular elections for the smooth functioning of the Panchayati Raj institutions. The 74th Constitutional Amendment Act 1992 proposes to constitute a uniform structure of municipal corporations, municipal councils, and nagar panchayats in transitional areas. This act granted urban local government a constitutional status. Presently, urban local government has three categories. First, nagar panchayat for a transitional area, that is, an area in transition from a rural to an urban area. Second, municipal council for smaller urban areas. And third, municipal corporations for large urban areas. An area is designated as a transitional area or a smaller urban area or a large urban area on the basis of size and density of the population of that area. The revenue generated for local administration and percentage of employment in non-agricultural activities, the economic importance or such other factors contributing to the designation of a particular area as small, transitional or large area. The governor of a state can provide by notification that a municipality may not be created in an industrial township if the municipal services are provided by the industrial establishment itself. Another type of town which does not come under the scope of above categories is that of army cantonment. If any towns have come up around an army cantonment, the management board of these towns are established and these are controlled by the Defense Department. These are known as cantonment boards. The seats of the municipalities are filled by persons who are elected directly by the people from the territorial constituencies within the municipal area. These territorial constituencies are known as wards. Now we come to the salient feature of the 73rd Amendment Act. The amendment stipulates for certain compulsory provisions which are obligatory on the part of the state government to incorporate in their respective acts. Some aspects have, however, been left to the discretion of the state legislatures to make suitable provisions in their act. The mandatory provisions of the amendment are: number 1, establishment of Gram Sabhas at the village level, comprising of persons registered in the electoral roll relating to the village comprised within the area of the panchayats. The state where the Gram Sabha does not exist will have to make such provisions. Number 2, establishment of a three-tier system of panchayats at the village, intermediate, and district levels in all the states and union territories, except in those having a population of less than 20 lakhs, where panchayats at intermediate level need not be constituted. The state which fall under this category as per the 1991 census are Goa, Sikkim, all the northeastern states and union territories. Number 3, all levels of panchayats will consist of persons elected directly from the territorial constituencies in the panchayat area. The territorial constituencies shall be carved out in such a manner that the ratio between the population of each constituency and the number of seats allotted to it should, throughout the panchayat area, as far as possible, be the same. Number 4. All members of the panchayats, whether or not directly elected, shall have the right to vote in the meetings of the panchayats. Number 5. The chairman of a panchayat at the intermediate and the district level shall be elected from among the directly elected members representing the territorial constituencies. Number 6. Reservation of seats for SC and STs in proportion to their population in the panchayat area. Number 7. 1/3 of the total number of seats, both in reserved and unreserved categories, shall be kept apart for women in every panchayat, and the seat may also be allotted by rotation. Number 8. The chairperson of each level of panchayats shall be reserved for SCs and STs in proportion to their population on rotation basis. Similarly, 1/3 post of the chairpersons of each level of panchayats shall be reserved for women on rotation basis. Number 9. A fixed tenure of 5 years for panchayats from the date appointed for its first meeting, and the tenure cannot be extended. However, if a panchayat is dissolved before the expiry of its term, election is conducted within a period of 6 months of the dissolution of the reconstitution of the panchayat. For the remainder of the term provided, the panchayat shall be constituted before the expiry of its tenure of 5 years. Number 10. Amendment of new law to dissolve the panchayat at any level is also prohibited. Number 11. A person who has attained 20 years of age is eligible for election or membership to the panchayats. Number 12. Constitution of a finance commission by the state within a year from the commencement of the Constitutional Amendment Act, initially and thereafter every 5 years, to review the finances of the panchayats and recommended principles on the basis of which the taxes to be appropriated by or assigned to the panchayats, as also granting aid to the panchayats from the consolidated fund of the state. The action taken on the recommendation of the commission shall be laid before the legislature of the state. Number 13. Audit of the accounts of the panchayat is also something that needs to be done. Number 14. A state election commission has to be constituted for the superintendence, direction and control of the panchayat at all levels. The state election commission, however, shall be removed in a manner and on the likes ground of a judge of a high court. Number 15. The act is applicable to all states and union territories. Exemption is being granted to certain states and tribal areas and other territories from the application of the provisions of Part 9 of the Constitution, and powers to the President and the Governor to modify the provision of Part 9 in their applicable union territories and scheduled areas, respectively. Number 16. The existing laws relating to panchayats which are inconsistent with the provisions of the Act shall continue to be in force until it is amended or repealed within 1 year. The existing panchayats shall continue till the expiration of their terms unless they are dissolved by the competent authority. Number 17. Under Article 243(o), the courts are barred from interfering in the electoral matters, such as the validity of any law relating to the delimitation of the constituencies or the allotment of seats to such constituencies. No election to any panchayats can be called in question except by an election petition as provided under the law made by the legislature of a state. Now we come to the salient features or mandates of the 74th Amendment Act. The Constitution's 74th Amendment Act, 1992, relating to municipalities or urban local government was passed by the Parliament. It received the assent of the President of India on 20th April 1993. The Act seeks to provide a common framework for the structure and mandate of urban local bodies to enable them to function as effective democratic units of local self-government. Government of India notified on 1st June 1993 as the date from which the 74th Amendment Act came into force. The Act provided for a period of 1 year from the date of its commencement, within which the then existing municipal laws, which were in force at that time in states and union territories, were required to be changed, amended, or modified in order to bring them in conformity with the provisions of the 74th Amendment Act. The salient features or the important features of this Act are: number 1, the constitutions of municipalities; number 2, the composition of the municipalities; number 3, the constitution of ward committees; number 4, reservation of seats; number 5, fixed duration of municipalities; number 6, power, authority, and responsibility of the municipalities; number 7, appointment of State Election Commission; number 8, appointment of State Finance Commission; number 9, constitution of Metropolitan and District Planning Commission. Action has been taken by the state and union territories to set up State Finance Commission as well as State Election Commission. All states set up their Finance Commission. Most of the State Finance Commissions submit their report to the concerned state government. The concerned state accepted nearly all the recommendations made by the respective finance commissions. All state governments and union territories set up their own commission for conducting elections to urban local bodies. Part 9 contains Article 243 and Article 243A to Article 243O. Article 243 relating to the definition has various terms as follows: district, which means a district in a state; Gram Sabha means a body consisting of persons registered in the electoral roll relating to the village comprised within the area of the panchayat at the village level. Intermediate level means a level between the village and the district specified by the governor of the state by public notification to the intermediate level for the purpose of this part. Panchayat means an institution of self-government constituted under Article 243B for the rural areas. Panchayat areas means the territorial areas of the panchayat. Population means the populations as ascertained at the last preceding census, of which the relevant figures have been published. Village means a village specified by the governor by a public notification to the village for the purpose of this part and includes a group of villages so specified. Under Article 243A, a Gram Sabha is empowered to exercise such powers and perform such functions at the village level as provided by law. As per Article 243C, the legislature of a state is empowered to make provisions with regard to the composition of the panchayats. The panchayat area shall be divided into territorial constituencies. The state is empowered to provide for the representation of the chairpersons of Gram Panchayats at the village level, at the intermediate level, or in the Panchayat at the district level, and the MPs of Lok Sabha or Rajya Sabha and the MLAs at a level other than the village level in such Panchayats, where they are registered as electors in Panchayat at the intermediate level and in Panchayat at a district level. The chairperson of a Gram Panchayat shall be elected in such manner as provided by law, and of a Panchayat at the intermediate level or district level shall be elected by or from amongst the elected members. Under Article 243J, the legislature of a state is empowered to make provisions with respect to the maintenance and auditing of accounts of the panchayats. Under Article 243L, provides that the provisions of Part 9 shall apply to the union territories. Under Article 243O, the courts are barred from interfering in electoral matters such as the validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies. No election to any panchayat can be called in question except by an elected petition as provided under law or made by the legislature of the state. Now we come to the issue of local governance in Jammu and Kashmir, which is slightly different from the rest of the country. In Jammu and Kashmir, the roots of Panchayati Raj were planted by Maharaja Hari Singh in 1935 by promulgation of Jammu and Kashmir Village Panchayat Regulation No. 1. A special department of Panchayat and Rural Development was created in 1936 to administer the 1935 regulation. By an amendment in 1941, the list of functions of the 1935 regulation was widened. By an Act of 1951, the Panchayati Raj institutions were adopted to be re-established. The Jammu and Kashmir government thereafter enacted the Village Panchayat Act in 1958, replacing the 1951 Act. The in-force Jammu and Kashmir Panchayati Raj Act came into force in 1989. This act provides for a three-tier Panchayati Raj system, which is called Halka Panchayat, Block Development Council, and District Planning and Development Board for the villages, block and district level respectively. Each Halka Panchayat consists or comprises of 7 to 11 panchas or sarpanch. The sarpanch and the panchas are elected directly by the people. A Nayab Sarpanch is nominated by the panchas of the Halka Panchayat. Nayab Sarpanch performs the same duties as those of the Sarpanch in the event of the Sarpanch not being in position to fulfill his or her duties. A village level worker will be the secretary of the Halka Panchayat. The provisions of the 73rd Constitutional Amendment Act are yet to be implemented by the government of Jammu and Kashmir. However, the state framed the Jammu and Kashmir Panchayat Rules 1996 based on its own Panchayati Raj Act of 1989. In a positive development, the elections to the Halka Panchayat were conducted successfully in 2011, while the state of Jammu and Kashmir is moving ahead with the Panchayati Raj provisions of the Act passed by the state legislature. It has not accepted the 73rd Constitutional Amendment Act in toto. Now we come to an analysis of the Gram Panchayat Development Plan, which is also called GPDP. Devolution of power, that is funds, functions and functionaries, the 3 Fs that are important in Panchayati Raj institutions. 2. The revision of guidelines to provide roles and responsibilities to Panchayati Raj institutions for planning, monitoring and implementation are the important aspects of decentralized planning. Article 243G of the Indian Constitution mandates preparation of plans for economic development and social justice by panchayats, and through this process, panchayats are expected to evolve into institutions of local self-governance. For the optimum utilization of resources for the benefit of their citizens, preparations of integrated development plans by Gram Panchayats has become a necessity. The Gram Panchayat Development Plan should ideally match people's needs and priorities and the available resources, and additionally mobilize local resources through a fair, inclusive, transparent, and participatory process. The focus should be on local development issues, local perception of needs and priorities, local analysis of problems and solutions, local resource management, all within a collective vision. A typical GPDP consists of following steps: identification of resources, which can be financial as well as human resources in the Gram Panchayat, generation of environment for participatory planning through mass media and local interactions, etc., situational analysis by assessing infrastructure, civic amenities, human, economic, and social development, natural resources, and participatory planning. Projection by prioritizing activities and assigning the appropriate person, timeline, performance indicators, and expected outcomes. Finalization of development plan of Gram Panchayat for both annual and 5 years. Technical and administrative approval. Institutional supports, including various information technology devices and instruments. Capacity building for participatory planning. With this, we come to the conclusion of our discussion. Although the 73rd Amendment Act, as well as the 74th Constitutional Amendment Act in India, has opened new vistas for establishing social, moral, economic, and political independence, it has become a Herculean task to motivate people and make use of the opportunities to become real citizens in a true democracy. A pursuit of the legacy of local government can help us realize that local government is the most natural form of government which lost its continuity due to the colonial rule, and its resurrection can enable us to participate in our own development process. With this, we come to the end of our discussion. Thank you.